The new FinCEN real estate rule is coming, and it's bigger than you think. Let me start with this. If you work in real estate, if you buy or sell real estate, or if you're involved in closings in any way, there's a new federal real estate reporting rule coming that many people simply don't know about. And when it applies, the closing won't happen without compliance. It's not optional, it's not flexible, and it's not something you deal with later. Starting March 1st of this year, 2026, certain real estate transactions must report detailed ownership and identity information to the federal government. Many realtors haven't read the rule. Most buyers and sellers haven't heard of it. And that gap between what the law requires and what people expect, that's where delays, frustration, and blown timelines will happen. Today, I'm going to walk you through this rule in plain English. Simple enough so my two youngest sons could understand it. So you know when it applies, what's required, and why this is bigger than people think, especially right here in Iowa. What FinCEN is and why this rule exists. FinCEN stands for the Financial Crimes Enforcement Network. It's part of the U.S. Treasury Department. Their job is to protect the U.S. financial system from money laundering, fraud, organized crime, terrorist financing. For years, FinCEN has noticed a pattern. Criminals weren't buying real estate in their own names. They were buying through LLCs, trusts, shell companies, and non-finance transactions. Why? Because it hid who they really were. Real estate, especially cash and entity-based purchases, became a place where money could move with very little visibility. This rule exists to close that gap. It's about transparency. Important. This rule does not apply to every transaction. Before anyone panics, let's slow this down. This rule does not apply to most traditional home purchases with a mortgage. Buyers purchasing in their personal name. Typical financed residential transactions. So if you are buying a home with a conventional loan in your own name, this rule probably doesn't apply to you. But when the rule does apply, it applies fully. There is no partial compliance. There is no workaround. And how this rule shows up depends in part on what state you're in, which matters a lot for Iowa. The 4 questions that decide everything. There are 4 questions that determine whether FinCEN reporting is required. Think of this like your checklist. Question 1, is the real estate residential? Residential real estate includes single-family homes, condos, townhomes, duplexes, triplexes, and fourplexes, and vacant land intended for a residence. If people live there or will live there, it's considered residential. Question 2, is the transaction non-financed? This is where a lot of people are going to get surprised. Non-financed does not just mean someone shows up with a briefcase full of cash. The transaction is considered non-financed if there is no traditional institutional lender involved, meaning no bank or credit union that already has federal anti-money laundering reporting obligations. That includes all cash purchases, hard money lenders, private lenders, seller finance transactions such as installment contracts. Let me be very clear here. If the loan is coming from an individual, a private fund, a hard money operation, or the seller themselves, those transactions are likely treated as non-financed under FinCEN's new rule, which means many hard money deals and contract sales will be reportable transactions if the other criteria are met. This is one of the biggest blind spots I see right now. Question 3, is the buyer an entity or a trust? This is the pressure point. If the buyer is an LLC, a corporation, a partnership, or a trust, FinCEN reporting is now on the table. If the buyer is a human being purchasing their own name, that's a different analysis. Question 4, does an exception apply? Yes, there are exceptions. Some examples include divorce-related transfers, inheritances, certain estate planning transactions, some trust-specific situations, transfers involving 1031 intermediaries. But here's the danger. Assuming you're exempt without confirming it. That assumption is what causes delays. That assumption is what blows up timelines. What information will be required, and how must it be handled? If the new FinCEN rule applies, a real estate report must be filed with FinCEN. That report includes the property details, the buyer entity or trust, the seller, how the funds moved. But the part people really need to understand is this: beneficial owner information. FinCEN is looking through the entity or trust to the real people behind it. Beneficial owners will be asked to provide their full legal name, their date of birth, their current residential address, government-issued ID information, such as a driver's license or passport, their ownership or control interest in the entity or trust. I know this is highly sensitive personal information, and FinCEN expects it to be handled securely, not by emailing copies of IDs back and forth, not by attaching documents to random messages. It must be collected, verified, and stored in a secure, encrypted environment. If this information is incomplete or inaccurate, the report won't be accepted, and the closing does not happen. Who files the report, and why Iowa is different? Only one professional files the report. In most states, this responsibility often falls on large national title insurance companies, organizations with built-in compliance departments designed for this kind of reporting. But Iowa's different. Iowa is an abstract state. We don't have a uniform title insurance-driven closing system where every transaction runs through a large corporate title insurer. Because of that, in Iowa, FinCEN reporting will not consistently be absorbed by national title companies. Instead, it's going to fall primarily on settlement agents and law firms handling real estate closings. That means FinCEN compliance in Iowa will be handled locally by the professionals actually running the closing, not by a distant compliance department. And that matters. Why realtors will feel this first. Even though settlement agents and law firms will be responsible for filing, realtors will feel this first. Because buyers and sellers are going to ask, why do you need this? We've never done this before. Why is this suddenly an issue? And the answer is simple. Because federal law now requires it. This rule forces sensitive conversations to happen earlier, whether people are ready or not. In Iowa especially, that shift will be noticeable. It's time to talk honestly about cost, time, and penalties. I need to be direct here. This is not a light compliance obligation, especially in an abstract state system like Iowa's. In states with centralized title insurance, compliance can be standardized and maybe even absorbed. In Iowa, compliance will be built transaction by transaction, managed locally, personally overseen by settlement agents and law firms. Proper FinCEN compliance requires determining whether the rule applies, collecting sensitive personal information, verifying and documenting that information, managing certifications and reliance, filing the report correctly, retaining records, and managing legal risk. In real-world terms, this can easily add 3 or more hours of professional, billable time per transaction. Sometimes more depending upon complexity and cooperation. That time has to be paid for. And here's the other side of this. Failure to file or filing an incomplete or inaccurate report can expose the reporting party to fines and, in serious cases, jail time is possible under this new federal law. This is not a suggestion. This is not optional. This is a mandatory federal reporting requirement. What we're doing at Danilson Law and how we protect your information. At Danilson Law, we've been preparing for this rule well ahead of the deadline. We operate in Iowa's abstract state system, where responsibility is local and expertise matters. We already use a secure encrypted portal called Closing Lock. Closing Lock is used to verify identities, protect against wire fraud, securely manages sensitive closing information. And we will use Closing Lock to collect and manage FinCEN required information as well. That means no random emails, no unsecured attachments, no casual handling of sensitive personal data. Clients may be new to Closing Lock, We've only been using it for a few months, but the system itself is well established and built specifically for secure real estate transactions. While many law firms are still learning about the new FinCEN rule, we already have the tools and infrastructure in place to implement it properly. That's not an accident, that's preparation. Final takeaway. Here's the bottom line. March 1, 2026 matters. This rule is mandatory, and some deals will not close without compliance. In Iowa, this work will fall on settlement agents and law firms. Sensitive information must be handled securely, and this is bigger than most people realize. The right response is not to panic. It's preparation. If this video helped you understand what's coming, share it, because most people still haven't heard this yet. And if you want a closing team that already understands how to navigate this new reality and protect your information along the way, that's what we do at Danilson Law.